Hi, I'm Karina Perez Ilić, and I'm the managing attorney at Vanguard Attorneys. My trial tip for young lawyers that they probably don't teach you in law school is you can't fake experience, but you can be the most prepared in the courtroom. The first time that you have to go to court and make an argument, you're going to be nervous. There's no way around that. And you're probably going to be up against a lawyer who's been doing it for years, even decades longer. And that's going to be scary. But here's the secret. Older lawyers don't have the same amount of time as younger lawyers do to prepare. They have to run law firms, manage people, teach other young lawyers, and probably have a lot of other personal commitments too. The strength and the power of being a young lawyer is that you have way more time and less responsibility to prepare for the hearing. Use that to your advantage. Everybody wants more time, and young lawyers have it. In fact, a lot of older lawyers are scared of the young lawyers because we know that you have so much time to prepare. Take that opportunity and invest in yourself when you're young. If you're the most prepared in the courtroom, odds on you'll beat that older lawyer you're so afraid of. So my tip to you is be prepared, be over prepared.
Hi, I'm Silvia Brett, and my first tip for young lawyers deals with how to take a deposition. A lot of young lawyers want to know, what should I do in a deposition? What if it gets contentious? And my piece of advice is, don't worry about it. Do not engage. You don't have to. The rules don't require it. And frankly, it's probably a better practice not to. You probably won't agree with everything your opposing counsel says, and certainly not during a deposition. So if they try to be contentious, if they try to be difficult, you don't have to talk to them. If they ask you questions, you don't have to answer. You are not the deponent. As a lawyer, all you have to do is either object to the form if you're the one who's defending the deposition on behalf of your client or on behalf of another witness, or make sure that the witness answers if you're the one taking the deposition. And the only time that the witness does not need to be providing you an answer is if there's a privilege that needs to be preserved.
Hi, my name is Karina Perez Ilić, and I'm the managing attorney at Vanguard Attorneys. My trial tip for young lawyers that they may not teach you in law school is when you're arguing in court, argue the way you would write. I know that sounds a little bit silly because we don't read from things when we're making an argument, but believe it or not, the way you do legal writing is the way you should argue in a hearing. Now, when you get to court, you might think, where do I start? And the first thing you should say is obviously introduce yourself to the judge so that you can get a relationship with your local judiciary, but then also very quickly tell them what type of case it is. Judges have to preside over so many different types of cases. Whether you have an injury case or a contract dispute, you need to orient the judge. And then from there, go back to the legal writing basics. It may sound boring, but the reason we write that way is because it's easy to understand and it's persuasive. So introduce yourself, tell them what type of case you have, and then start with what you want them to do. Judge, you should grant my motion because, and then explain why. It sounds simple, but what I'm really doing is the way they teach you how to write in law school. The IRAC, track, or crack method, depending on where you went to law school. The way you write is the way that you should argue. It's easy to follow and it makes sense. And most people don't think about that in hearings, but never forget, speak the way you write. It'll help you in court. Best of luck to all you young lawyers.
Hi, I'm Silvia Brett from Vanguard Attorneys, and my tip for young lawyers that they don't teach you in law school is continue to read the rules. I've been practicing for 7 years and I still continue to read the rule because every situation is different. And every time that you reread the rules, depending on the context and the facts of your situation, new things start to stick out at you. And frankly, the rules are the most persuasive authority for the judge. So the rules and their advisory committee notes are extremely helpful. Save yourself some time, save yourself some heartache, read the rules.